May it please the Court, Your Honor. I'm Bill Gressley from Jacksonville on behalf of the appellant, George Morgan Waters, Jr. My aspirational goal is to reserve 2 minutes for rebuttal.
Okay. Well,
It occasionally works, but not
all
often.
right. It's your time. Use it as you will.
The initial issue raised was about the pleading of the affirmative defenses and counterclaim, and I believe the briefs completely discuss that to the extent that I don't want to use any of my time to deal with that issue unless the court has questions, because it's a pleading issue. Our position is simple, that we raised an issue that is legally recognizable. It required a factual determination to put any meat on any argument about the propriety of finding an agreement not to partition in this case. We haven't gotten there. It was dismissed as a matter of law on the face of the pleading based on the plaintiff's assertions that it was an attempt to enforce an oral contract for the sale of real property, which it was not. The real issue that I want to spend my time talking about and why I requested oral argument is because we have a very unique situation here legally. I've spent 30 years doing appellate work, and a long time ago it was a lot of condemnation in land use cases that involve valuations. And I understand the case law is the liberality of making a determination of comparability, indulging the trial court's discretion, but there's a limit. And I think that if I had to sum it up, I think the quote from the third in the Samter case, that apples may not be compared to oranges even where an expert evaluates the botanical distinctions between them, is the essence of my argument on the comparability. What has to be understood in order for this case to make any sense legally is what kind of property we're talking about. There's no dispute that the property can't be physically divided. There's no dispute that these brothers both want it sold. The only question is how much. The only issue presented at the hearing was really the appraisal testimony of each side with their supporting cast of realtors.
Let me ask you a question. Isn't the agreement to list the property and not seek partition, isn't essentially that about the disposition of the real property?
It is an agreement on how they're going to dispose of it.
But I mean, an agreement on how is basically, it centers on the issue of the disposition of the property, right?
If you agree with that, then it's a PCA on my first issue. I disagree. It's an agreement that this is how we're going to deal with this. We're going to have a listing. There was one with Sotheby's that was being performed when the plaintiff filed this partition action. And I believe the case law, the discussion in our brief really fleshes out that you can have an implicit agreement not to seek partition, so long as it's not indefinite. And the issue here was simply, how long do we have to go keep lowering the prices? We have nothing but the pleading. We have no facts because the judge dismissed this amended counterclaim.
Well, if your claim about this case is it's only about valuation, if they're both going to get equal parts of this, right? Isn't there an interest on both sides to maximize the sale price?
There is, but we're talking about two different things. The first issue that I raised.
I'm just responding to
you
said that's what
that's what I wanted to use my oral argument time about. If you agree with me on the first issue, then we don't have to go anywhere except a remand on the issue of whether there was an enforceable agreement. But I think you've got to reach the valuation question as well, because if my position carries the day, that this was an unacceptable attempt to compare non-comparable properties to come up with a value, then you've got to not only reverse on the first issue on the pleading issue, but you also have to set aside the $1.8 million valuation that the judge entered and the contract, which is the second order on appeal here.
Well, counsel, I think I'm with you if I recognize that in terms of you saying that it's all about, in essence, valuation in some ways, because no matter what we do, you're going to end up at the same place. I mean, if we agree that this should have gone to a private listing and it should have been by contract, you're still going to end up at the same place, having a difference of opinion of evaluation. I mean, both of the parties agree that it needs to be so.
We don't know that, Judge. We were in the middle of trying to list it and slowly lowering the prices when the plaintiff filed a partition suit. So we don't know anything except that there was an agreement.
Okay, so that by listing it, and I'm trying to see the practicality of this lawsuit. I mean, as to why. So by listing it, it's possible that your price would end up higher than what the trial judge has said.
We do, and if I can.
I mean, that's what's in it for you.
Yes, and what I can jump to something farther afield than I planned to, which is that within weeks of the judge entering the order approving this contract for 1.8, we have a cash buyer as is. Tells me that we hit a low figure. But legally, the real prime issue here is that the plaintiff's appraiser refused to recognize in any substantive way in his valuation opinion that what we have here is a very unique piece of property. It's an estate-sized lot, 3 acres. Yes, it's very narrow. It's 100 feet by 1,300 feet, 100 feet on the intercoastal right across from Jupiter Island and Tiger Woods House. Right next door is a federal wildlife preserve. Right beyond that is what was referred to as the Campbell Estate property, which was listed for over $5 million. And then besides that was the Burt Reynolds property, which had just miraculously come on the market 2 days or a week before the hearing. The real issue here is that the trial judge found that the plaintiff's appraiser's use of the third of an acre lot in a subdivision next door as a comparable with only a $50,000 adjustment. We're not talking about building values at all. All this is raw land values. Was somehow legally comparable and much better in terms of the practicalities because he used the local location and the local area. Judge ignored.
Isn't that a finding of fact? I mean, isn't the standard on this going to be abuse of discretion? I mean, yeah, you can say that you disagree with it. Maybe we disagree with it, but what's the standard we have to review that?
Competent substantial evidence. Our position is that the plaintiff's appraisal does not represent competent evidence. It represents pure speculation. And that is the essence of our brief on this issue. That the Samter case and the other cases relied on point out that, yes, we give broad discretion to trial courts to make findings about whether something is comparable, but there's a point beyond which trial courts cannot go. Yes, it is an abuse of discretion.
On one hand, you're saying that this is a unique property, and on the other hand, you're criticizing the valuations because there were none that were similar to this unique property. There may not be anywhere that's going to satisfy either side.
There are, but here's the ultimate conclusion of my argument, which is the ones used by plaintiff's appraisal, the majority of them had no deep water access because the buyer for this property is going to be someone who wants to build an estate type of home like the Burt Reynolds property where you have carriage houses and guest cottages and swimming pools and tennis courts, and you can pull your 100-foot yacht up to the front of the dock that doesn't have to be very far because it's deep water and there's no impediment to getting to the ocean. All the Pinnock Point properties and the ones on the Loxahatchee River that were all used by the plaintiff's appraisal, you've got a fixed bridge that's got a 12-foot opening.
It sounds like you're asking us to relitigate the similarity of the properties. So why are we in a better position to do that than Judge Mermin?
What I'm asking you to do is recognize that what is being proposed by plaintiff's appraisal is legally insufficient to be comparable. It's the same kind of mental fiction that the appraiser in Samter came up with, which he said, well, I've got an embankment near an interstate that I have to value, so I'll just find one that works. Well, the comparability stopped there. It was an entirely different situation. It wasn't something out in the middle of nowhere that he used as a comparable and then just made up an adjustment. We recognize, the law recognizes that every valuation and comparison of properties inherently carries some differences. Some adjustment has to be necessary. The question is whether there's a discernible chain of fact-based reasoning that goes behind those assumptions, and it's our position that the valuation provided by plaintiff's expert here was not legally sufficient to allow the judge to base the valuation opinion on it. I would like to save my minute and 16 seconds for rebuttal if I could.
Yes, you may.
Thank you.
Good morning, Judge Stevenson, Judge Levine, Judge Klingensmith. May it please the court, my name is Jim Bowdish with the Crary Law Firm in Stuart. I represent the appellee, Michael Waters in this case, who is seated here behind me on the right. We're asking the court to approve both orders that are under review in the consolidated appeal. The order having the property be listed for sale with a realtor at $1.8 million, and then the subsequent order entered by the court in which the court approved an actual sale of the property and a contract for that sale, again, at the same price, 1.8 million.
Has the person who has that contract entered the lawsuit? Are they?
No, he's not a party to the lawsuit. He's just simply standing by, and the contract has, obviously an exception that if you should reverse it, then the deal's off. So he's standing by. It's been almost a year now. I would hope that the court would affirm both orders per curiam without opinion, so we don't have to go further on this up the ladder. But to deal with a couple of questions, my opponent did not deal with the issue of the striking of the pleadings and the dismissal of the amended counterclaim. I want to touch on that very briefly. Your roadmap for that is the Condrey case decided in 1957. If I cited no other case, the Condrey case would be your guide. Now, the Condrey case clearly stated, if I can read from the opinion, in the last question posed by the plaintiffs, it is contended that an oral agreement not to partition is not enforceable because of the statute of frauds. This would no doubt be true. This would no doubt be true if the agreement not to partition had not been performed in part. So the Condrey case is basically saying that the statute of frauds requiring a written agreement does apply. But in this particular case, it was partially performed, or actually fully performed. We've cited other cases more recently in the 2000s. The Condrey case is still good law. The Condrey case, in talking about the agreement
stood
not
for the
to,
proposition that the statute of fraud would not prohibit the partition.
well, the Condrey case, first of all, it says the statute of frauds does apply, but if there is an agreement not to partition, and that an oral agreement,
Right.
then that is performed, then that takes it out of the statute of frauds. And the Condrey case dealt with a couple who transferred title to themselves and their son and daughter-in-law so that this elderly couple could be maintained for the rest of their lives. And the court found when the son filed a partition suit that it could not be expected or anticipated that the couple would lose their property to a partition sale. In this particular case, we have a pleading that says that there was an agreement not to partition, that it was oral, and that as a result, the parties were to list the property for sale and reduce the listing price as they agreed. Well, that's just an agreement to agree. And under the Condrey case, the agreement not to partition has to be, quote, otherwise enforceable. So if this agreement had been in writing, would the court enforce that? The answer is no, because it has to be a valid contract. And a contract to agree to reduce the property in the future as needed until it's sold is unlimited in duration, which violates the Condrey case. And it is also, it is just simply an unenforceable contract to agree. So we cited those cases in our brief. Now, my opponent didn't argue them, but I just wanted to make sure I touched on that. Now, going to the other argument regarding the appraisal valuations. We had two appraisers. They testified at an evidentiary hearing. Both appraisers were competent. The court found they were qualified to render opinions. Both appraisers used the time-tested sales comparison approach. Both appraisers agreed that the land value was all that matters, not the fact there was an old dilapidated house or a broken dock on the property. Land value was all, so they both look at that, and they had to go out and find comparables. Now, the court permitted me to use a demonstrative exhibit. This is Exhibit 3 in the This is Exhibit 3 in evidence. This red line indicates the property. Below this is the Rolling Hills subdivision. One of these lots, I think it was lot 39, was used by our appraiser as a comparable. And that lot sold for 1.5. Now remember, the court ordered 1.8 as the test. So we had our appraiser coming in at 1.6. As Mr. Grassley pointed out, this is a preserve area to the north. This is US 1 over here on the left. And across the water is Jupiter Island. Now, Mr. Grassley's appraiser picked a lot from Jupiter Island. Now that's like looking across the tracks the wrong way. I mean, obviously, everybody agreed, the appraisers agreed that Jupiter Island is a very wealthy community, one of the wealthiest in the country. I'm not saying that that appraiser was wrong. I'm saying that these are questions for the trial court to decide once the evidence has been admitted. There was no objection made to the written appraisers' appraisals coming into evidence. There was no objection to their testimony. No motion to strike the testimony. Nothing was done. The judge ruled at the conclusion of the hearing and then entered the order for listing the property at 1.8. So we just have simply a classic case of a conflict between two very qualified appraisers who agreed on a lot of stuff, but they had a difficult time finding comparables when you have a piece of property that's 1,000 feet long and 100 feet wide. It just was difficult. One went across to Jupiter Island all the way down to Delray Beach out on the island to use a comparable. That was his appraiser. Ours used comparables in the area, and both appraisers had to adjust from there. So it was just simply a difficult job.
Did the
court
appraisers
had to
use
weigh
any
the
nearby
testimony.
properties that were listed but had not sold at certain prices?
I'm sorry?
Did any of the appraisers use nearby properties which had been listed at certain prices but had not sold? For example, the Burt Reynolds property. I mean, that had been
the
on.
Burt Reynolds property.
Hold on. Burt Reynolds property, I think you said, had been listed or
Yes.
relisted a couple of days before this.
Right.
That
That's
property, I mean, read the newspapers, it had been listed and been on the market for years at a
Right.
certain price and had not sold.
Right.
Did any of the appraisers take that into consideration?
No, because that property had not been sold. It was just listed. Now, how did this come into evidence? It came into evidence by our realtor, who testified that she had learned that this property had just come up on the market. And so in trying to tell the judge why the judge should allow her firm to list the property for sale, she compared this property with the Burt Reynolds property. And the Burt Reynolds property is about a quarter of a mile up US 1, but it's the same sort of piece of property. What is significant is she testified that that property was appraised by the Martin County property appraiser at $1,575,000. Once again, we're talking about 1.8 is what the judge did.
But appraisal value isn't market value, is it?
No, this is the Martin County property appraiser's valuation of the property for tax purposes. Okay, this property was also appraised by the Martin County property appraiser for $1,575,000 because the land value is all that matters. Burt Reynolds had a helicopter pad, he had a movie theater, he had all sorts of improvements, but both appraisers that testified at the trial agreed that land value is what was important. So here we have the Martin County property appraiser appraising the Burt Reynolds property at $1,575,000 and our property at the same.
His appraiser came in at what, about 3 million? Was that it?
His appraisal came in at $3.2 million.
3.2.
The Kolkonsky appraisal was $1.6 million, so it's half of that.
So, just as a practical matter, I mean, it's in both interests to have a higher
Oh,
valuation.
sure. Absolutely. Yes, it is. But remember, the brothers initially listed it at 8.5 million, and that didn't go anywhere. So exactly what the proper price to list it was
Now,
a
we're not, are
question
we
for the
stuck
judge.
with ever the trial court, in your opinion, your argument is that we're stuck with as the factual finding that the trial court makes?
We are, well, once evidence is admitted, then the weight to be given that evidence is subject to an abuse of discretion standard.
Still has
So
to be
yes, you
competent,
are. You
substantial.
are stuck with it unless you agree with Mr. Grassley that it is totally incompetent evidence.
Well, Counsel, one thing I see, though, is that the Kolkonski appraisal looks at properties that are much smaller. I mean, this is
Yes.
this is a 3-acre property.
That's
and,
true.
And all of the
Yes, that's true.
the comparables
Exactly
were
right.
much smaller. I mean, does that impugn enough the report so that we could step in and
No. Both appraisers agree that the sales comparison approach was proper, but both appraisers had difficulty with that because there just weren't any, other than the Burt Reynolds property, which they did not consider. There wasn't anything else nearby that they could use. So our appraiser looked at lots and properties in this area. The other appraiser took the approach that, well, because these are smaller lots, I've got to go over to Jupiter Island and pick a lot over there, which is, of course, we would suggest is apples and oranges. And I have to go down to Delray Beach out on the island and pick a lot down there. Both appraisers agreed with the sales comparison approach. Both said it was difficult to do this. Both did the best they could. Both appraisals were written, and in the appraisal it was stated that it was done in accordance with the standards of appraisals, or whatever the proper term is. So we really don't have anything other than a disagreement over evidence that was admitted without objection. And there was no motion to strike filed, there was nothing like that. The appraisals came in without any objection.
Well, Counsel, I understand how both parties might be interested in maximizing the amount of sale. Of course, in many instances, one party may be interested in a quicker or faster sale than the other party, and I suspect this is probably what we're dealing with here. But in any event, I
Okay,
appreciate you.
thank you very much, I appreciate it.
Briefly, Your Honors, thank
Yes,
you.
sir.
The question is whether the appraiser for the plaintiff even got to the threshold of reasonableness of his appraisals. And our position is he did not, and here's why. Yes, it was difficult, but not impossible to find comparable properties. And the problem here is the plaintiff's appraisal, there were 3 aspects of this property that had to be addressed. One was the estate size of it so that you could build swimming pools, tennis court, and guest cottages. Secondly was the deep water ability, so you didn't have to have a very lengthy dock like you did on the Pinnock Point properties. And third was the unimpeded access to get to the ocean. None of the properties used by the plaintiff's appraiser accounted for that, and he acknowledged in his testimony that he had done no analysis of that, did not have any concept of whether the 4 of his 6 properties, which were on the Loxahatchee River and had to face this fixed bridge, could handle any boat of
But
any
Counsel,
size.
you know, while your total acreage at 3 is estate size, the configuration of it is so narrow that you know, a person with that kind of money may not want to have to.
Your Honor, it
Build on
is
such a-
virtually
yeah.
identical to the Burt Reynolds configuration and the Dr. Campbell estate configuration next door to Burt Reynolds. That was never raised as an issue at all. What was raised by my side from the moment the judge announced his ruling was This is not comparable. He doesn't, the plaintiff's appraiser has not at all made an adjustment for the size of this property and the estate value that a potential purchaser is looking for, the ability to have deep water access without a massive dock, and the ability to get to the ocean without having an impediment.
What does the trial court do if you're faced with a situation where neither side's comparables really reflect what this property is?
Well, I don't know the answer to that. I know in this case ours were. The reason that the Jupiter...
So they're saying that the Jupiter Island and
Jupiter Island was used because it met the criteria, state-sized lot, deep water, and no impediment to the ocean. I would like to end with...
But that's almost like saying, you may have all those things, but in Hope Sound you've got that, but you have it in Palm Beach as well. You're going to take a Palm Beach valuation to do that with a Hope Sound property?
With a proper reduction because of higher value somewhere else. But you can't, what the plaintiff's appraiser did is he looked at this as, okay, I've got 100 feet on the water to build a house. Where else can I find 100 feet on the water to build a house? That was not the issue. The issue was, can you build an estate-sized property with the amenities on this property? Can you get to the ocean without the impediment? Because all of his comparables with any size, the Pinnock Point properties being the prime example, 4 of the 6, had no ability to get to deep water without a large dock, and then they faced an impediment with a bridge that severely limited the size of boat that could get there. Those factors mean, in our position, that the plaintiff's appraisal was not legally competent to support what the judge did. The last thing I want to leave you with is the judge made a comment at the conclusion of the closing arguments that he believed the partition statute required him to enforce an expedited process. And I think that if you wanted to look at why the judge went this way, that's what his primary factor was let's do this quickly. So I'll go with a lower value. Thank you, Your Honors.
Thank you. Court will be in recess. Thank you very much.